Well, here we are again talking about a new subject. Today let's talk about corporations. So we've covered a lot so far in terms of business organization, talked about sole proprietorships, business organizations generally, had a detailed discussion of partnerships, and then finished up with LLCs. Now we're going to talk about corporations. So tracking what is contained in the Maller book on chapter 41, sort of as background, as we indicated, corporations, have been around a long time, several hundred years, and they basically coincided with the growth of the Industrial Revolution. And as we have talked about, it's a very, very important development insofar as it enabled the growth of industry and commerce, the utilization of capital, the incentive to create businesses by encouraging people to invest their capital with the full knowledge that their investment would perhaps yield great returns, but in the absolute worst case, the worst that would happen to them is that they would lose the value of their investment. Hence the phrase limited liability. The liability of the investor, of the owner, of the capitalist, of the shareholder is limited to the value of their investment. So this, of course, encourages people to make investment more so than if everything they had were on the line, and has helped facilitate the growth of commerce and business. So this is a very, very significant thing, and one we've emphasized before. Classifications of corporations: there's for-profit, there's non-profit, there's government corporations. We do not cover nonprofits, as important as that sector is in this economy. We do not cover that here in this business class. We're only focusing, and nor do we do government profit or government-owned businesses. We're only covering private for-profit companies. There is, as we talked about, state law, as there is with partnerships and LLCs. It's all driven by state law. Many of the corporations are incorporated in Delaware. We will discuss that in more detail and get into that further. But Delaware is sort of the main place of incorporation historically for companies. But it's state law is the important point to emphasize. There are private companies and there are public companies. Public companies, the book gives General Electric as an example, but obviously there's many others. There's Apple, there's Google. There's many, many other examples of public companies. Just open any access point to the listings on NASDAQ or the NYSE, any of the major exchanges. You'll see that those companies are publicly traded, meaning you can buy shares in those enterprises and own them. You too can be an owner of any of those companies. Right now, you can stop this tape. If you have the money to purchase a share or two, you can go online and execute those trades very easily. That's another component of corporations. As we may remember, while there are restrictions on LLCs and partnerships, the shares of corporations, unless there's restrictions expressly stated otherwise, are freely alienable or freely transferable. That's another tremendous value of a corporation, and one reason, or a corporation structure, and that's one reason why they've grown to the level that they have, because these shares are freely alienable or freely transferable. So in addition to that, we have this notion of limited liability. So those are probably two of the key cornerstones of the corporation. But as I said, we've got the public corporation, publicly traded corporation, shares anybody can buy. But we also have private or closed corporations, and that describes a lot of corporations, in fact. There's nothing that precludes us, again, right now from stopping this tape, going ahead and deciding to incorporate ourselves. All you've got to do is file the requisite paperwork if you wanted to file in California, incorporate in California, or incorporate in Delaware, but operate to do business in California. You have to file some additional paperwork for that. That's known as foreign corporation status that you'd have to obtain if you wanted to operate in California, if you were a Delaware corporation. But at any rate, you file these papers typically with the Secretary of State in California. That's who we would file with, likewise in Delaware. And state would approve it or not. You'd file your articles of incorporation and pay the requisite fees. And that's pretty much how it works. Unlike a partnership, which can be established, as we learned, by the basis of the conduct of the parties or the execution of an express agreement in the form of a partnership agreement, no specific filings, if you will, are required with the state. By contrast, LLCs, you must do that. Similarly, in corporations, you also must file something, and we'll get into that in a moment. We talked about the distinction between S versus C, right? Meaning S corporation versus C corporation. S refers to the subchapter of the Internal Revenue Code, which creates an exception for the regular class of C corporations that is restricted, however, to the number of shareholders. So S corporations are limited to 100 or fewer shareholders. If you're within that number, you can file as an S corp. And as we had already discussed, the great value of an S corp is what? It's a so-called pass-through entity, no different, therefore, than a partnership or an LLC if it's structured as a partnership, whereby you're not taxed at that entity level, meaning the corporation enterprise is not taxed, but those levels beneath it, meaning the shareholders, are. So you avoid what's known as double taxation. Double taxation. And double taxation is a problem, as I think we gave an example in one of the earlier lectures. Insofar as its name suggests, you're taxed twice. You're taxed at the corporate level, but you're also taxed at the individual shareholder level, and that can have a real consequence on what you're able to obtain in terms of the net monies to you. So again, suppose you've got the corporation up here, and then you've got the two shareholders. Say you've got just two shareholders in this corporation. If the corporation earns $100 and it's taxed at an effective rate of 20%, that obviously leaves a net of 80. Well, that 80 is then distributed, let's say, in the form of what? In the form of, say, a dividend. And say it's distributed equally to both. So what would they get? Obviously, they both get 40. Okay, so that works nicely. That would be the net to them. By contrast, if you were an S corporation, that same $100 would not be taxed at this level, at the corporate level. Instead, it just passes directly through to each of the individual shareholders. So instead of the net 40 to each, what would they have? They'd obviously have the net 50. So you can see, whatever the effective rate is to shareholders, they're going to be receiving more in the context of an S corp versus a C corp. So it's really kind of a no-brainer to set it up that way in the form of an S corp if you can. But there's severe limitations, as we talked about, notably the limitation on the number of shareholders. An Apple or a Google could never set up as an S corp. And indeed, any sort of company that's trying to get significant outside investment in the form of venture capital, private equity, and so on, is typically going to set up as a C corp, precisely for the reason that this is a lot more flexible. And you're going to want to offer shares, of course, not just to the private equity guys and the big investors, but you also probably, most good companies want to incentivize their employees, particularly their senior level management, so they can perform. This whole notion of pay for performance. And we'll get into that, particularly when you're reading the Brehm v. Eisner case and other elements. But it's an important concept that you should be aware of. It's really kind of a buzz phrase, but it's just really stating a common sense principle: pay for performance. If you perform well, you get paid well. Essentially, is what this is saying. And how do you get paid well? If you perform well, one of the greatest measures is what's the value of the company, i.e., what's the value of the stock. So a lot of senior people are going to, again, particularly for the good companies, are going to want to be incentivized, not just in the form of a salary or a bonus, but, okay, I own a piece of this company. If the company does well, I enjoy the benefits with it, and we've certainly seen that. And we'll see a lot more examples of companies that have done enormously well, and not surprisingly, their employees have done quite well with it. Google and Apple have made many, many millionaires, and not just for the most senior people, but for even some of the mid-level management. So it's been a great thing for them. Let's take a look at Figure 1, and like a lot of the figures in these sections, specifically in the partnership and the LLC and the corporations, these are very useful summaries. So I do go over them, and I will go over this one again here. Now, kind of recaps what's in a lot of the readings elsewhere in the book. As we kind of indicated, you got to start with the creation. So unlike a partnership, which can be created again by the conduct of the parties, remember how a partnership is created just by virtue of maybe using that word partner or partnering, and maybe a split of the profits and an agreement to split the losses. You may never have actually executed a partnership agreement in that scenario, but if you have facts like that, it's very possible that you do have a partnership and the law will construe that. So you got to be very, very careful. But note how you don't have to actually file anything with a state agency or the government. In other words, the government doesn't have to provide their imprint, their approval, their sanctioning of that conduct. By contrast, LLCs, and again here with corporations, big time, you need to go through those steps of filing something. So it's only created by the permission of the government. And we'll get into the Articles of Incorporation, but that's essentially how it's done. A corporation is a fiction, meaning it's not a real person, right? It's not something that breathes or has life or has any sort of biological components, but it's treated as a legal person under the law, and that's why we call it kind of this legal fiction, similarly to a partnership or an LLC. It has three main elements associated with it. And what are those? It has officers, it has directors, and it has shareholders. What we'll call kind of the trinity of the corporation. So it's the shareholders, the directors, and the officers. So why don't I quickly write that down? Shareholders, officers, and directors. Okay, very simple, right? And it's it's all over the place. This is not, I think, probably news to any of you, hopefully, at this point. Shareholders are the owners, right? In the basic governance of a corporation, the shareholders who are the owners. In theory, we could just stop right there and say, you're the owner, you control things, you call the shots. And in theory, that's 100% true and the case. However, we will see through the rest of the semester, through future lectures, through our discussions, not always the case as a practical sense, meaning you have this push-pull phenomenon with officers and directors where they have a vested interest, they have a stake in the enterprise as well. And they're often much closer to the situation. Indeed, certainly the officers would be. So you get this kind of almost entrenchment that is a real issue. And it's a real issue in governance, and it's a real issue in how corporations actually operate from a practical perspective. But anyway, these guys own it. What's the role of the officers? The officers are not, they can also be shareholders, by the way, and you can wear different hats, and we'll see how that can work as far as your rights and responsibilities when you wear those different hats. But they're not the same thing. They are distinct obligations and distinct set of requirements. But when you're an officer, you're basically running the day-to-day enterprise. You're running the corporation. But they're the most senior level of the organization, right? So when we say officer, right, we mean titles, CEO, right? We've heard that phrase before, right? Chief Executive Officer or CFO, right? It's Chief Financial Officer, or CMO, Chief Marketing Officer, or CLO, Chief Legal Officer, CTO, Chief Technology Officer, CIO, Chief Information Officer. There's several of these titles. They're all officers. They're all the most senior level people in the organization who are running the show. They're employees. They're running the company. Critical role, obviously. So if you've got these guys who are the owners, these guys who are running it on a day-to-day basis, the top guys running it, what's the role of these guys? What's the role of the directors? Well, I like to say they kind of have an oversight role. Okay? And what do I mean by an oversight role? They have an oversight role. Well, first of all, who reports to the directors? Meaning, who are they the boss of? Well, they're the boss of the officers. The officers report to the directors. The directors are the guys who ultimately have this oversight function. They set the general parameters, set strategy, but the officers are ultimately answerable to the board of directors. The board of directors are their boss. So who's on top? Who's more important? Well, they're all kind of important in their own way, but if you think about it, the officers really kind of have to answer to the directors. So the question then is, who do the directors answer to? Who do the directors answer to? Well, ultimately the directors answer to the shareholders. So you've got shareholders who elect, and actually let me erase this, who elect directors who in turn manage the officers, right? So it kind of goes like that. So this seems to imply that these guys are more important than these guys, and these guys are more important than these guys. Not necessarily. Remember, who's closest to the situation on a day-to-day basis? These guys. So these guys have a lot of the information, most of the good information, and the most current and the most valuable in terms of what's actually happening. These guys are one step removed. They're often hearing from these guys what's going on. And in theory, these are the most far removed because they're not in the company at all. And I'm thinking now about real big companies. Suppose you buy a share of Google, or suppose you're a major shareholder of Google. And suppose you're not a director and you're not an officer. Because again, you can be all three. A lot of these officers, remember I told you, are incentivized to work by virtue of the fact they're becoming shareholders, because the expectation is the share price will go up. It'll be that whole, flip to this one, it'll be that whole pay for performance thing. They're going to get paid for their performance. But the reality is the shareholders are pretty far removed from what's going on, unless they also happen to be officers or directors. But at any rate, in a large company, it's the shareholders who will elect the directors, and the directors will select the officers. And actually, I misspoke, not just in large companies, also in small companies too. That's sort of the basic process. The difference is in a small company, if you have just a couple shareholders, these people all tend to be the same in many instances. So there's less of these kind of governance issues because you're all kind of one and the same. They get to be a lot more complex and frankly interesting in a larger enterprise, and we will get into those distinctions. But these are the three main groups: the shareholders, the directors, and the officers. Each of them have a direct responsibility. These guys are the owners. Their liability is going to be limited to the value of their investment because it's a limited liability company. As directors and officers, we learned about the phrase in the context of partnerships and LLCs of fiduciary duties. Remember that? You should know it really well now. It's that highest duty that exists beyond the ordinary duty of care, wherein you place the interests of the enterprise above your own interests. That's exactly the obligations that both directors and officers have to the corporation. They are fiduciaries to the corporation. There's some language or a small little section at the end that talks about instances when a shareholder could be a fiduciary. Just forget about that. Don't worry about that. That's really kind of an outlier and not something we need to think about or study. And to highlight that very point, if you are a shareholder in Google, you buy 10 shares of Google today, you're not a fiduciary. But Sergey Brin, who's an officer and director of Google, Larry Page, who's an officer and director of Google, they are fiduciaries to the corporation. They have to place their own personal interests below those interests of the corporation. So it's an important duty. It's a duty we'll be coming to again and again in this section. Okay. back to legal status in principles and characteristics. I mean, the life is unaffected of the corporation, could potentially go on indefinitely, and is not going to be affected by changes in management or the death of a shareholder or the death of an officer. If the CEO of, to pick a random company, Coca-Cola, were to die unexpectedly, if the whole senior management team, heaven forbid, were to die unexpectedly, it's not going to change anything in terms of the existence of the corporation. It will go on unless affirmative steps are taken to shut it down or declares bankruptcy or what have you. But the bottom line is, and when I say bankruptcy, I don't mean some reorganization, but actual liquidation, then the corporation ceases to exist in that limited circumstance, but otherwise continues to go on indefinitely. Like a partnership or an LLC, a corporation can acquire, hold, or convey property in its own name. It can sue and be sued. It just, as I said, just no different than a person. The number 4, as I indicated, the shareholders elect the board of directors, which manage the corporation. Rather than manage, I prefer to use the phrase oversee the management of the corporation, or set direction of the corporation. It's more of an oversight function. It's the board of directors who then delegate that to the officers, who delegate those responsibilities of day-to-day management to the officers. As I already indicated, shareholders have no right or duty to manage the business of a corporation unless he or she is elected to the board of directors or appointed as an officer. Now, to be an officer or director, as the book correctly points out, you don't need to be a shareholder. You could be a director or officer and have no shares in the company. That pattern exists. In a public company, that'd be very unusual because, as I said, again, you want this pay-for-performance concept. The idea is that the directors and officers' interests would be aligned with the corporation, so that if the stock price of the corporation goes up, their respective share interests go up as well with it. So that's a real alignment, and everybody benefits in theory in that scenario. So that's why shareholders and directors are often shareholders, but they don't need to be. Directors and officers don't need to be. And in a private company where maybe you have a couple shareholders, they may say, you know what, we don't want to give out, we don't want to share in this. Pay for performance, yeah, it's a great concept, but we could just give people cash bonuses. We don't need to give them, and frankly, we don't want to share our ownership interests. We don't want that to be owned by anybody else. And that's a perfectly valid as well way of running things, and that's how sometimes smaller businesses are run, and that's okay. But as I said, the typical pattern, particularly for larger companies, is not that. Owner's liability, we talked about this. Shareholders have limited liability with few exceptions, and we'll get into those exceptions, specifically piercing the corporate veil, where they're not liable for the debts of a corporation after they've paid their promised capital contributions to the corporation. Transferability, generally the ownership interest in a corporation is freely transferable. A shareholder can sell their interest to really anybody that they want. We talked about taxation. S corporation, there is not double taxation, but you have these extreme limits on the number of shareholders. You cannot have foreign owners, meaning non-U.S. citizens, as owners in an S corporation. So there are restrictions that are significant, but otherwise the S corporation is a great way to go because you don't have the double taxation. Now, we talked about the distribution of dividends as a way to distribute cash to shareholders. That's not the only way, right? What is the other way that shareholders can gain? And I'm already kind of giving you away half the answer. Can gain more money as a result of their ownership interest, or gain money, I should say. Well, the obvious answer is liquidating, selling your stock, and that's really ultimately what people, I think, are aiming to do, right? It's not just the idea of holding on to something and watching it grow. I mean, I suppose we can get enjoyment from that, but ultimately you only fully realize that gain until what? Until you actually sell You could see your share price go up from $2 to $4 to $8 to $16 to $32 to $64, and so on. Until you actually sell it, though, you haven't realized any gain. It's what we call so-called, sometimes you hear people refer to paper gains. That's kind of what that is, because if it went from 2 to 64 and you didn't sell, you wanted to hold on, you could see the price maybe, as business circumstances change generally in the economy and in your company specifically, go back down and go all the way to $1. So, even though it went up to as much as $64 in my example, the argument would be that, well, gee, it went all the way back down, and I am now, on paper at a loss. Well, that's too bad. You probably should have sold at 64. The question then is, okay, what's your tax if you sold at 64? Well, if you bought at 2, you just subtract the $2 from 64, right? And then the leftover part would be your gain, or what we call your capital gain. So again, let me just quickly illustrate. Suppose you bought your shares at 2, right? And then over time, just up the graph, just went like a complete hockey stick, or call that the hockey stick growth, went up just dramatic growth. So say now it's at 64. Well, congratulations. So what do? You want to sell. Your capital gain is this. You subtract your basis, or what you bought the share price at. And there's plenty of people better than me to explain this, and probably even some of you who have tax experience. This is not a tax class, but just to illustrate, I mentioned dividends earlier. It's not just dividends distribution, but it's also an opportunity to make money in the context of selling your shares and getting a capital gain. That's a big reason why we get into buying stocks to begin with. Okay, so as I said, I'm now at 1035, regulation for for-profit corporations. We're not going to be covering nonprofits, so you can disregard that. Like with RUPA for Revised Uniform Partnership Act, or Rule Code, the Revised Uniform LLC Act, there are these statutes at the state level, but there are these model statutes, and RULCA and RUPA are such model statutes. We're really going to kind of go to those, even though we're going to be covering a lot of state law cases, specifically Delaware cases. But what that's called is the MBCA, the Model Business Corporation Act. So that's what we're going to primarily look to as an example. Now, regulation of corporations. This is an important concept that we need to cover. We talked about in one of the earlier examples, if we want to set up a corporation, you need to get the approval or the filings in place with the various states that you want to operate in, specifically also the one you're incorporating in. But say you incorporate in Delaware, but you're a California corporation. How does that work? Well, most corporations, or many corporations, still elect to file and incorporate in Delaware, simply because, it's evolved law. It is a long tradition. It is administratively more convenient and considered to be easy to do filings there. For all those reasons, sense of prestige even of being a Delaware corporation. Not tax reasons, by the way. There's a misapprehension that I'm going to file in Delaware for taxes, because again, you're going to be taxed on where you're actually doing business and where you're operating. And we'll get to that in a second. But it's not the case people are going to file in Delaware simply because of some perceived tax advantage. You sometimes see that with Nevada, people thinking there's some perceived tax advantage. Unless you're actually moving your business to Nevada and operating a business there, it's probably not going to have any sort of impact. But people, as I said, do choose Delaware for those reasons: administrative convenience of filing, a lot of experience of the people in Delaware with that, good case law, favorable case law, a sense of history, kind of follow what other people have done and continue in that sort of way of doing business. But also, it's a it's a sense of prestige, frankly, for some, that it has this kind of history associated with it, as opposed to being, and not to pick on another state, but say an Idaho corporation or an Oklahoma corporation, or frankly even a Nevada corporation. A lot of good laws there. More and more people are incorporating in Nevada. Again, not for so much for tax reasons, but for some of the same reasons why people would want to maybe do in Delaware, because they try to make it easier. But there's still certain stigmas associated with gaming and so on that people may not want to affiliate with as much. So at any rate, enough said on that. Delaware is the main choice. But if you elect to go with Delaware and you're a California corporation, you still have to file as a foreign corporation in all those states you do business. In this case, absolutely California, because this is say where your headquarters is. And we'll see in the Brehm v. Eisner case, I don't know if we'll get to it today, but that was a Delaware case. Why? Because Disney's incorporated in Delaware. But where is Disney headquartered? Disney's headquartered here in Burbank, California. So there's a classic example of it. So if you're organized in Delaware and you're doing business in Florida, you're known as a domestic Delaware corporation and a foreign corporation in Florida, and you've got to file paperwork with the state of Florida to that effect. Due process. We talked about origins or sources of law. We talked about the U.S. Constitution. These are concepts that now come actually from the U.S. Constitution. One of the rare instances in this class where we will do that, but it actually does apply here in the context of how do you determine if there is going to be taxation of a corporation? How do you determine if there's going to be the ability to bring in a corporation into a particular lawsuit? These are all considerations with respect to the due process clause. With respect to the doing business clause and the taxation issue, also affecting the commerce clause of the Constitution. But the whole big picture concept here is, do you have enough contacts with this particular state? Do you have a strong enough connection with this state so that you could potentially be subject to taxation and or be a party to a lawsuit and be sued in that state? These are the things we're going to want to be looking for. What are these connections to the state? And these are again important concepts. Due process clause, commerce clause. In the case of commerce clause, we come to not just taxation, but regulation of certain activities, whether or not you need to maybe get certain permits. And there's some very good examples in the book we'll cover in a second. But 1036 has a good standard, and I'm not going to, or states the standard well. I'm not going to write it up on the board here, but on page 1036, under the Commerce Clause, a state law regulating the activities of a foreign corporation is thought to not unduly burden interstate commerce, meaning it will be deemed to be subject to the regulation and not deemed to be in violation of the Commerce Clause if that law in that particular state serves a legitimate state interest, number one. Number two, the state's chosen the least burdensome means of promoting that interest, and that legitimate state interest outweighs the statute's burdens on interstate commerce. So let's unpeel that a little bit further. The law serves some legitimate state interest, so the law has to be serving some legitimate interest, and that could be in the eye of the beholder, but it can't be something that's discriminatory, designed to sort of single out certain enterprises over others. It's got to be some sort of legitimate purpose. Second, the states tried to find other means to implement the law and to implement the regulation, and they've found no other method that's better, that this is the least burdensome in promoting that interest. And third, that legitimate interest outweighs the state's burden on interstate commerce. So that interest trumps, if you will, any of the burdens that may exist on interstate commerce. So 1036 has a good discussion about subjecting foreign corporations to a lawsuit. It mentions the international shoe case. I'm not going to hold you responsible for that, but please do read it nonetheless. But just know generally, long-arm statutes have been created that allow jurisdiction to fall within international shoe, and all international shoe simply did is establish what's known as the minimum contacts test for it to be met to subject a defendant to a jurisdiction of a court in that other foreign state. Okay, so let's talk about taxation, and this gets into, I think, some very interesting issues and covers both the due process clause of the 14th Amendment and also the Commerce Clause, as I mentioned, both U.S. constitutional issues and some of the rare instances in which constitutional issues would come into play. So, again, back to the first class when we're talking about sources of law, if you've got a conflict between what's deemed to be something of a violation of the Due Process Clause or the Commerce Clause versus, a state statute, which is going to take precedence? Well, the U.S. Constitution. So in each and every case, if that state statute is found to violate the U.S. Constitution, or even the state constitution is found to violate the U.S. Constitution, each and every case the U.S. Constitution will take precedence over it. So taxation, something that governments have to do to raise money and money to support things that we use, right? The state level, we're supporting taxes to make to fund this institution, for example. The public schools, if you went to public schools and high school and junior high school and elementary school, funded by taxation and revenue the government gets. So businesses are taxed, not just individuals. So how do you tax a foreign corporation if you're a state? Well, you can do it so long as it doesn't violate the Due Process Clause or the Commerce Clause. And we already enumerated the Commerce Clause standard on page 1036. I won't read it again, but those three tests, beginning with it serves a legitimate state interest. So the book gives a good example. If you've got a North Carolina corporation that has property located in Pennsylvania, it's going to be subject to the property tax of Pennsylvania. Okay, it's a foreign corporation, but why would it be subject to the tax? Well, it's enjoying some of the benefits of being in Pennsylvania, right? Fire department, police force, street cleaning. That's going to be important, particularly in certain parts of the country where the weather is very severe, where it snows and so on. All these are tax-supported activities. As a property owner, you are enjoying some of those benefits. So therefore, you should pay your fair share, what's deemed to be your fair share. And you could legitimately, Pennsylvania doesn't have to tax them. They could say, we're not going to have a property tax. That's their choice. And probably wouldn't be a bad strategy to encourage businesses to actually come to their state. But at any rate, if they wanted to do that, they wouldn't be precluded from doing that, wouldn't violate the Due Process Clause or the Commerce Clause. Now, greater contacts are needed to subject a corporation to state income and sales tax. Okay. The basis for the state tax not violating the Commerce Clause is that the activity has a substantial connection to the taxing state. It's fairly apportioned. It doesn't discriminate against interstate commerce, and it's fairly related to the services provided in the state. Okay, so it's applied to the activity with some substantial connection to the taxing state. It's fairly apportioned, and it does not discriminate against interstate commerce, and it's fairly related to the services provided in that state. So again, the book gives a good example. I'll have another one for you in a moment as well. But New Jersey is permitted to tax a portion of the net income of a corporation for the privilege of doing business in that particular state for employing or owning property or capital or maintaining an office there. And it's going to be, determined by the ratios of in-state property to their total property, to their in-state to total receipts, and their in-state to total wages, salary, and other employee compensation. So in plain English, I'm not going to hold you responsible for each of these, but just know that if you have some connection to that state in terms of sales, in terms of employing people or deploying capital or property, the state that is in, or the state where those activities are taking place, the state can apportion a proportional tax based on your activities there. So for example, if you've got, say, $100 in total revenue that you're generating across all your offices, and you're a California corporation, you're doing business in Nevada, you therefore have to file, you're a domestic California corporation, but you file as a foreign corporation in Nevada. So you have $100, but you generate 10 of those dollars in Nevada, you could fairly apportion, or Nevada could fairly apportion 10% of that, of the $100, or $10. And it's going to be based on those ratios. The in-state property to total property, if it's a property tax, the in-state to total receipts. Similarly with the wages, you've got to pay various state taxes for your employees. And that too would be apportioned. Now, could Pennsylvania, have a tax on all trucks that drive through Pennsylvania? And the answer is no, they can't. That would be deemed to be an undue burden on interstate commerce. It would unfairly single out interstate trucks as compared to trucks that just that operate within Pennsylvania. In the sense that the intrastate, meaning the trucks going within Pennsylvania, are going to be driving a lot more within Pennsylvania than perhaps just passing through, once a month. For Pennsylvania highways on the way from, say, Delaware to New York, you may have to drive through Pennsylvania. It's not going to be considered reasonable or fair. Now, that would be an undue burden on interstate commerce. Now, the book does give an example of a fee levied in Michigan on all trucks, whether they were owned in-state or out-of-state, on the grounds that the fee taxed purely local activity and didn't tax any interstate trucks' entry into Michigan or transactions spanning multiple states. Now, again, I can't really speak to that as a fair outcome, but there you have it. There is one case, one Supreme Court case actually, which ruled that. But the general idea is, and I think that's probably more of an outlier, you've got to have some more of a legitimate connection to the state. Let me give you an example of professional athletes. When LeBron James was playing for the Miami Heat, you may all probably know LeBron James, the famous basketball player. He played in Florida. Florida has no state income tax, and that's a reason why, nor does Texas, for example. Another big pull or reason why it's easier, I think, for teams in those states to get good players is because, as compared to a California, New York, where you're giving 10% of your income to the state, these are huge sums of money. To the extent people are motivated by those things, it's a large financial incentive. Anyway, when he played for the Miami Heat, he'd pay no state income taxes on the money he earned in the 41 games during the regular season he'd play in the home stadium. But when he was on the road, playing in, against the Knicks in New York, or the Lakers here, or the Clippers here, or the Warriors up in the Bay Area, he'd have to pay a proportionate tax, believe it or not. So if he played, say, a total of 6 games all season in California, they would do this proportioning, this ratio calculation, taking the 82 games, the 6 over the 82, and figuring out what his overall income was based on those 6 games, and he'd pay a tax accordingly. So it's interesting how that works. E-commerce is another example. How do you get around, or how has Amazon historically gotten around not paying, not having to pay sales tax? I mean, that's a huge advantage if you think about it. You walk into, buy something at, well, it's not books anymore, obviously, but you walk in, you buy anything at a retail outlet in California, you'll be paying a hefty sales tax, 9.5%, 9.25%, whatever it is, depending on where you are. When they tack on the local taxes, you can avoid a lot of that by online purchases. And how do they get around that? Well, they don't have any real strong nexus to California. That's how they've gotten around it. They operate in places where there are no such taxes. So that's continually something that the government's looking at, ways to kind of get revenue, and a lot of revenue that's just not simply being taxed at all right now, or as much as it perhaps could be. All right. As I said, we're not going to worry so much about regulations of corporations' internal affairs, nor will we talk about nonprofits. So this takes us to piercing the corporate veil. Piercing the corporate veil. And this is a very important area of the law. I want to take a short little break right here, and I'll pick up with piercing the veil. Okay, so we're back to talk about piercing the veil, continuation of the corporation section. We had talked about how the fundamental idea of any corporation is that it's a limited liability situation for the shareholders. That is, the maximum that they could lose is the value of their investment. But we know that in most laws sets forth the basic principle, the basic concept. That is the basic concept in this case, that value of your investment, your losses are limited to the value of your investment. That is something that there's an exception for, and the exception here is piercing the veil. And the idea is there's certain conduct that we're not going to let anybody get away with and just say, I'm going to set up a corporation knowing full well the worst that can happen to me is I'm going to lose the value of my investment. We're going to say here, no, instead there is a set of requirements that, if met, will pierce directly through that concept of limited liability. Think of a veil as a covering, right? What is a veil? So when you pierce it, meaning you're just puncturing it, you're going right through it. What's the veil, though? The veil is the limited liability for the shareholders. What we're saying is when we pierce that veil, we're coming up with a scenario where, you know what, that limited liability that we talked about is no longer in effect. We're going to cut right through it. We're going to pierce right through that veil and grab and attach the assets of the shareholder, because their assets are the ones that are going to be fully exposed and subject to liability. So that's an extraordinary thing if you think about it, right? Because the whole foundation of a corporation is limited liability. So we're saying, no, there's certain circumstances where we're going to just disregard that. We're going to blow right through that. We're going to pierce right through that veil, and we're going to dig into the pockets of the shareholders, excuse me, and make them pay exactly everything that they may have to satisfy this judgment, not just limited to the value of their investment. So what are the circumstances where that could arise? Because clearly that's an exceptional, extraordinary situation. Well, 2 requirements are needed before we get to understanding what situations that might be. First is there has to be domination on the part of the shareholders, and I'm at page 1042 if you're following along. There has to be domination of the shareholders, and two, that domination has to be used for some sort of improper purpose. So one, domination, two, improper purpose. Let's take the first one, domination. What does that mean? It means there's a group of shareholders, or even frankly just one, who controls the corporation. That the shareholder is essentially running everything. There's no real separation between what the shareholders' activities are and the corporation's activities are, and that person dominates it. So this seems to suggest that, can you have a piercing the corporate veil situation in a large corporation, a large publicly traded corporation? I think the answer is be a real challenge, unless you had a publicly traded corporation that had, some dominant shareholders or a dominant shareholder. Much more difficult, I think, to demonstrate in that circumstance. Therefore, this seems to suggest piercing the veil, you're going to exist more in private corporation and closed corporations where you have a limited number or a sole shareholder, where one shareholder clearly, or a couple shareholders clearly dominates the activities. Now remember, if you don't have domination, you don't have piercing the veil. Why? Because you need both requirements. You need piercing, you need domination, and you need the improper purpose. You could have one but not the other. You could have a horribly improper purpose, evading taxes or polluting the Santa Monica Bay. That is an activity that would be an improper purpose. But if you don't have domination of the shareholders or a shareholder, you're not going to get to piercing the veil. It's a very kind of formulaic thing. You got to have both of these requirements. Having just one is not enough. You got to have both of them. So if you don't have improper purpose and domination together, you're not going to get to piercing the veil. As I indicated, piercing the veil is more likely going to be in these more closed corporations. So when we say domination, as I said, the company is kind of what we call an alter ego of yourself, meaning you're essentially, the company is synonymous with you. It's kind of an appendage. The other courts sometimes say the corporation acts as an instrumentality, as an instrument of the shareholder. So think of it as like an appendage or a leg or an arm of the actual body of the shareholder becomes that part of the corporation. Essentially, those shareholders dominate it so much that they are synonymous. They're one and the same with a corporation. It's difficult to separate the two. So it becomes this alter ego, this instrumentality. So that's kind of the domination piece. What is the improper purpose or improper use? It could be really three types of categories here are identified. Defrauding creditors, meaning you've got a creditor that you owe money to, right? A creditor, by definition, is someone you owe money to. And you are doing it to basically avoid having to pay them consciously. It's not that you just default because you don't have the money, but no, you're actually taking steps to kind of weasel your way out of it by setting up other sort of enterprises. That would be defrauding creditors. Second, circumvention of a statute. What does that mean? Getting around a statute. That's what circumvention means, sort of bypassing it. And what's a statute? It's, as we know, a source of law. It's a law in the books. So you have a law in the books, and you're actually seeking to evade it. An example of that would be there's statutes which prohibit the dumping of toxic wastes. You could say, hey, I'm engaging the improper purpose of just dumping my toxic waste into the stream that I know they're going to go into the bay, and they're going to be pollutants. And I've set up this corporation simply to get around that because I don't want to be personally liable, so I'll set up the corporation and it'll do it for me. That would be deemed to be setting up something to circumvent a statute and would be a basis to pierce the veil. What's an example of defrauding creditors? Defrauding creditors, as I said, is, you've got some sort of financial obligation and you're not actually fulfilling it. The book gives a couple of examples, concepts of what's known as thin capitalization and looting. And they fall within the sort of the heading of defrauding creditors. What does thin capitalization mean? It means if you form a business and it has a very high debt to equity ratio. So, if you have a business which has, a lot of operating activities, but you only have a very limited amount of capital. So you don't want to start a business that, you've got all these assets, you've got all these obligations, but you only have, capital of $1,000 or a few $1,000s. That would deem to be a thinly capitalized business. And indeed, frankly, a lot of businesses suffer from that problem. They just don't have adequate cash to kind of keep things going. But if you're borrowing money to support a business, but you are knowingly not having a lot of money behind you, taking on a bunch of debt, that could be something that could be, the basis for piercing the veil if you're too thinly capitalized. And we'll get into the concept of thin capitalization in some other examples later. But for here, it could be a basis for somebody to say, hey, you're defrauding your creditor. Why? Because you didn't have adequate capital relative to the debt that you were taking on. And that's just common sense, right? But again, that by itself is not enough. You've got to show the domination and those other things. Now, looting. This is another way that you could defraud a creditor. It's basically just another way of saying, stealing. You're pillaging from the corporation. You're taking from the corporation, assets that are not yours. They're the corporations, right? Because they're separate entities. But you're treating them as if they're yours. You're kind of feathering your own nest at the expense of the corporation. Well, I guess that's okay. I mean, it's really not, but let's say it's okay if you're the sole shareholder, right? You're basically essentially stealing from yourself. So what are you going to do? Sue yourself? That doesn't really make any sense. But it's when you start to bring in the rights of other parties where it starts to become an issue. Other shareholders, right? Other shareholders may not appreciate if you're taking money from their corporation because that's their money. Another situation that wouldn't be appreciated, and now is the example here, is if someone has lent you money, and when I say you, I mean the corporation, and you as a shareholder, say as a sole shareholder, are paying yourself an excessive salary, are taking assets out of the company into your personal accounts, that's stealing. You're stealing from this corporation. And again, if you've got no other party involved in this, no one's lent you any money, there are no other shareholders, at some level, you could say, okay, what's the big deal? It could be a big deal later on if, you're sued, but suppose that never happens. It's probably nothing will ever happen to you because there's going to be no one to bring a claim for piercing the veil. They could bring the claim when they have certain rights to the assets of your corporation. A judgment creditor, for example, or someone who is a creditor who's lent you money. If you're looting from the corporation, taking money that really isn't yours, it's the corporation's, remember, it's not yours, you don't have the rights to it, then someone has the basis, again, if they can establish domination, could show improper purpose under the category of defrauding a creditor. So take a look at that section. Circumvention of a statute. I already kind of gave you, an example of, an ordinance for environmental law, but it's based circumvention just means bypassing. It means trying to figure a way out of, weaseling your way out of it. Third is evading an existing obligation. If you have a specific contract, that you're obligated to perform, yet you're dominating the company and you engage in a way that is, I don't really care. I'm just going to blow off this obligation that I have to perform this $100 million contract, and I really don't care because it's not me, because it's a limited liability company. You know, a court could conceivably pierce the veil because they would suggest that, you know, you've tried to escape liability by simply entering into this agreement that you knew full well you would never possibly perform. So that's another potential basis. That one's a much more sort of qualitative one, much more subjective one in some respects. So the focus is more on circumvention of a statute, defrauding creditors. That's really what we're going to mostly focus on. Nonprofit companies, again, we're not as interested in that. Examples of piercing the veil. There's a very good chart again here on Figure 2. So please do take a look at that. I can go through one or two with you right now. It's probably a good idea to do, but I really want you to read this carefully and try to understand it. Let's take a look at the first example, and it sort of describes the event in a very sort of basic, simple fashion, establishes whether or not there may be domination, establishes whether or not there may be proof of the improper purpose. Again, those are the two requirements, and then boom, it gives you the result. Is there liability or is there not liability? So in the first example, there's a sole shareholder. So just stop right there. Sole shareholder. Does that give you a sense, antennae should pop up, you know, domination potential, right? Because there's just one. So setting that aside. So sole shareholder director, who also happens to be a director, causes the corporation to pay the shareholders' personal debt. Okay, that's interesting. Proof of domination. Sole shareholder director controls the corporation's use of assets. Okay. Proof of the improper purpose. Creditors are defrauded when the corporation's assets are used to pay the shareholders' debt, not the corporation's debt. This assumes that the corporation has existing debt, obviously. I don't think that's really stated in the facts, but that's the assumption, that the corporation has some existing debts, and you're essentially diverting these funds from the corporation to this personal individual shareholder. Now, if there were other shareholders, right, involved, you know, they could bring claims also for what? We're not just talking about piercing the veil here. Obvious, you know, breach of fiduciary duties, conflicts of interest, you know, taking actions adverse to the corporation. I mean, a whole host of claims could be brought, but in the context of piercing the veil, we're talking very specifically about claims third parties would have against the corporation to recover monies that would have been otherwise owed to them, be it creditors, possibly even other shareholders. So in that result, you know, shareholder is going to be liable to the creditor's corporation, that first example. Okay, here's another example. Shareholders, directors fail to hold annual shareholders and directors meetings. Okay, well this is an interesting one, because you do have to follow corporate form. That is one of the potential downsides of a corporation, as opposed to, say, you know, a partnership or even an LLC, and certainly a sole proprietorship. If you could go with that, you've got to really follow corporate formalities. If you fail to follow corporate formalities, including failure to hold regular meetings, you can pierce the veil. There is no question about that. So shareholders, you know, fail to hold the annual shareholders and directors meetings. The shareholders and directors control the corporation's decisions to hold those meetings. And what are you doing? What's the basis? There is a statute requiring to hold these meetings. There is a circumvention issue, right? There is potentially a circumvention issue, circumvention of the incorporation of the statute requiring those meetings. Result or outcome, boom, shareholder is liable to the creditors of the corporation. Again, if there's a claim for that. So read through the others. There's some good other examples here as well. take a look at the Hildreth case. I'm not going to go over it here, but this is a piercing the veil case, and it requires some statutory interpretation. But please do read that. You'll be obligated to be responsible for it, and take a look also the problem cases that were assigned, number 6 and number 9, the B&D Shrimp Inc. and the New York law requiring the taxi cabs. And actually, I would like to talk about the taxi cab one here, because it's a good example for assessing whether or not there is liability in the case of corporate separation. Okay, so there's a New York law, and again, with the growth of Uber and Lyft, it's kind of changed the landscape for rides and use of rides and so on. Before Uber and Lyft really were there, I mean, taxi cabs were really the main way to get rides. If you didn't drive yourself or have someone drive you who was a friend or a colleague. And it's very regulated. And the level of regulation would depend on which city you're in. It'd be regulated locally. New York City, notorious for steep regulations, and with that, limiting the number of taxis. And they were given these medallions or these coins, which have significant value to them. And I don't recall the exact amount, but many hundreds of thousands of dollars, I think even in some cases at 1.7 figures, for the right to own and operate taxis in the city, in New York. So just by virtue of owning one of those was extremely valuable, and there was a market for them. People would buy them from others and so on. So at any rate, with that background, New York law required that every taxi cab company require liability insurance for each cab in its fleet. So $10,000 minimum liability, which really isn't very much. But at any rate, that was the requirement. The purpose of the law was to ensure that passengers and pedestrians would be adequately compensated for their injuries. I mean, that's just common sense, right? If for whatever reason the taxi company didn't have adequate assets and they were negligent, they would be on the hook for that amount if they didn't have adequate funds to make the payment. Because again, you could have great facts in a negligence suit, as we know. You could establish duty, breach, causation, proximate cause, and damages. You could have $1 million case. Great, wonderful. But if the other party that you sued doesn't have adequate assets to fulfill or pay that judgment, it's a hollow victory, right? You really haven't gained anything. So the idea is to cover those circumstances, require people to have insurance, because we know insurance will back that up, and insurance companies, other than in rare instances, are going to be solvent. So the requirement here was $10,000 per cab. This guy Carlton organized 10 separate corporations, each owning and operating 2 taxis, and each carrying $20,000 of liability insurance, right? You understand? So he's got a fleet of 20 taxis. He just put 2 taxis in each corporation, setting up 10 corporations. Notice how he could have just had one corporation and put all 20 in. Instead, he set up 10 separate corporations, put two taxis in each. And each of the corporations, per the statute, had $20,000 in it. Carlton was the principal shareholder of each corporation. The vehicles were the only real transferable assets of the corporations and were collateral for claims for secured creditors. Okay, I know we talked a little bit about secured versus unsecured in some of the other lectures, but let me recap that here. Again, if it's secured debt, what does that mean? It means it's a debt, meaning it's a debt that's secured by some form of collateral, right? So the most obvious one is, and forget this case for one moment, you buy your car, you don't lease it, say you buy it. If you don't pay cash, you pay whatever your down payment is, and then you make your payments over, say, 3 years, 5 years, whatever long you financed it. If you stop to make payments, the lender can do what? They can take back the asset, in this case the collateral, in this case the car. The car is the collateral. So that's what we call a secured financing arrangement. Okay, the debt is secured by the collateral. In this case, the collateral is the car. Same example with a house. If you buy a house, most people don't pay all cash for it. They put down payment and they finance it. Over time, they pay it down. But if they fail to make payments, it can be repossessed by the bank or the lender, and it's secured. It's a secured debt secured by the house itself. So the security is the asset itself, is the collateral. So that's what we call secured debt. Unsecured debt is, credit card debt, right? You're just lent the money. Obviously, you got to pay it back. If you don't pay it back, you have consequences of, having credit reporting, adverse consequences, collection agencies, difficulty to get further credit, judgment liens. I mean, you have really a whole host of bad consequences, but there's nothing backing up the debt, meaning there's nothing that the debtor is putting up to secure the debt. It's just them personally. So if you want to be a creditor, obviously being secured is a much better place to be for a whole host of reasons, including the one we just talked about. But the point is here, this guy, when he set up his company, the vehicles were the really only assets that he had, but the vehicles themselves were collateral on other debt that he had taken on, other secured debt. Okay? So that would tend to mean what? That if another creditor came in trying to collect something, they would have to get in line behind the guys that already had the secured debt on that collateral of those cars. Okay? So you'd have to be in a situation where, is there really anything to collect, because those cars are already secured by another creditor. So now the 10 corporations were operated more or less as a unit with respect to supplies, repairs, and employees. So there was no real separation between the corporations. To maintain and preserve the limited liability component of a corporation, you have to maintain that wall of separation. Failure to maintain that separation will result in the potential of a piercing of that veil. This circle is the veil that protects the corporation, but we're going to blow right through that limited liability concept if there is domination and there's this improper purpose, and in the context of understanding the conduct of the shareholders who may be subject to piercing the veil, we look at the improper purpose and we look at their conduct. Did they keep a separation here? And again, go back to Figure 2 on page 1044 of Mallory. That gives you some good examples there. Circumvention of the statute with not having regular bylaws. Here, what did they do? They didn't treat the 10 corporations differently. They treated them really kind of intermingled or commingled into one, because they shared supplies, they shared employees, they shared repairs. So anyway, this poor guy, I can't pronounce his name, call him Mr. W, was severely injured when he was run down by one of the taxi cabs. So he sues Carlton, the owner of the company, the shareholder, personally. Well, what is Carlton going to want to say? Well, wait a minute, I set up these 10 corporations. You can't sue me personally. I'm not responsible. It's the corporation. And furthermore, which corporation? This guy set up 10 different corporations. I won't draw 10 circles, but he set up 10 different of these, 10 of them. So he's not going to be able to probably sue all 10. Carlton's going to say, no, you just sue the one that owned the cab that you had the accident. Well, guess what? The primary asset of that corporation, the cab is already encumbered because it's secured by another creditor. So you can't get to that, Mr. W, so good luck. We really have no other assets. So really, you just get the insurance, the $10,000 or the $20,000 maximum, which is the total amount of the total insurance I have for this corporation. So what W is saying, though, is forget that. This is a multiple corporation structure that amounts to fraud upon those who might be injured by the taxi cabs. That this guy deliberately set up these companies so that he would escape liability. So the question then is, should the course pierce the veil to reach Carlton individually? And that's a great question. And at some level, kind of a hard question, because we don't have a lot of facts, but we do know that these 10 corporations really were not treated so separate, and that's going to be viewed potentially very, very badly. It could be viewed as a circumvention of a statute, and that's very much where this guy could likely get into trouble. So you could argue that would be a good basis maybe to pierce the corporate veil, because clearly there's the first requirement. He does dominate it. And secondly, it's designed, the activity is designed for some improper purpose. Now, did he set up the company with the intention of committing the fraud? We don't have enough facts, but we do have facts which suggest that there was no real separations and they shared employees. That would be violating a statute. That would be violating probably a series of statutes and could be the basis for circumvention and therefore reaching to a point where you pierce the veil. Whereas, assuming he had just set up all 20 companies, or excuse me, all 20 cabs in one company, then you would have a lot more available for insurance recovery. You'd conceivably have 20 times what he's offering for one cab, or $200,000 instead of $10,000. So the idea is you could maybe get to those insurance monies more easily if you had one company. The other element is, again, we're going after Carlton, right? We're going after Carlton as an individual. So it's not just the assets anymore of the corporation. The whole idea of piercing the veil is you're not just going after the assets of the corporation, but you're going to dig and reach into the pockets of that particular individual and try to sue him individually, which is exactly what Mr. W is trying to do here in the form of piercing the veil. So again, to recap, domination and improper purpose. You need both of them. If you don't have both of them, you don't have a piercing the veil situation. When we're looking at domination, we always want to look at a situation in which you've got maybe one shareholder preferably, or a small group of shareholders who really do dominate. And if it comes up on a factual pattern in the future, it's going to be clear whether or not there's domination or not. And the improper purpose piece, really for us, there were three factors listed in the book: the design to evade an existing obligation, defrauding creditors, or circumvention of a statute. We're really going to focus more so on those last two, circumvention of a statute or defrauding a creditor. That will be the improper purpose piece. You also want to look at the entire set of circumstances. Are they not creating this level of separation among corporations and respecting corporate formalities as they need to? Well, boom, that can get you into the circumvention of a statute component, and that runs the gamut from failing to maintain minutes, to failing to properly incorporate, to failing to pay or to keep employees separate as they otherwise would be required to do. Okay, this takes us to chapter 42 and organization and financial structure of corporations. So let's talk a bit about this. Promoters are the people who are involved in sort of developing a corporation, sort of putting it all together, sort of the entrepreneurs responsible for incorporating the business, organizing the initial management team, raising capital. These sorts of folks are people who are going to want to move quickly. It's often the case that they'll start executing agreements before the corporation's even established. So the question then is, how do they do that? How can you start to enter into contracts if the corporation doesn't exist? And that's a very good question. How do you do that? In theory, you shouldn't do anything until the corporation's set up. The reality is we need to move quickly. So what's going to happen is sometimes people will just go ahead, sign in their own name, then the corporation's established. So the question is, what do you do about those agreements that occurred before the corporation is established? Well, it's really kind of common sense, right? The idea is anything that occurs before the corporation is established is going to be, on that person. So we'll call it the individual. It'll be on the individual, meaning it'll be the responsibility of the individual. Once the corporation is established, however, is if the corporation, and this is the advisable thing to do, is they formally adopt, the book uses the phrase adoption, but they formally adopt the contract. And they then adopt it, and then they ratify it. So what you'd want to do is the corporation in their, would hold a board meeting. They would identify those contracts that were pre-incorporation contracts, and then they would say, okay, we hereby agree to adopt and ratify them. Okay? So that's the first step, and that's the first step in effectively assigning or transferring the contract from individual to corporation. But it takes two to tango. Who did that individual enter a contract with? They entered into it with somebody else, right? We'll call that person Mr. X. Well, it's all well and good for the corporation, once it's established, to ratify, to adopt and then ratify it. But if this guy, who was the original other party of the contract, says no way, no how, you still don't have a contract. The contract actually has to be assigned or novated. The book uses the phrase novation, and now I'm on page 1052, but the contract has to essentially be novated or assigned by agreement to that third party, X, who's the other contractual party. So it's really just, common sense principles, right? The idea is entrepreneurs are going to move quickly. They may move first without actually having a corporation yet. That's fine. But once you do establish the corporation, make sure that you formally, have the corporation adopt the contract. You want to hold, corporate meeting and minutes and document it. Adopt it, then they officially ratify it. That's the first step, and then you actually have to move to the other party and have them agree to accept the new agreement, and that's what we call a novation or assignment of that agreement to that third party. The Smith-Stearns case is an interesting little case. Again, a Delaware case. So you've got a company called Smith-Stearns Yacht, which is a Delaware corporation that provides yachting services, agreed to a contract with a communications company, which was a California company. And this communications company would provide marketing, advertising, and promotional services. So Smith-Stearns then sues this marketing company, Gyrographic, for breach of contract. The Gyrographic countersues, which is not an uncommon outcome. I'm going to sue the other party, then the other party says, I'm going to sue you as well. Smith-Stearns then says they're not a party to the contract because the contract was purportedly made with a limited liability corporation, or limited liability company, I should say, Smith-Stearns Yacht LLC, not the corporation that was suing Gyrographic. So what actually happened in this case? This guy, Stearns, who was the promoter, executed the agreement with Gyrographic on behalf of the LLC. Unfortunately, this LLC never actually came into existence. So the plaintiff in the case, Smith Yachts Inc., was formed. Smith-Stearns Yacht Inc. contends that it has the ability to bring the action because it assumed and ratified both explicitly and implicitly the agreement that was made on its behalf prior to the formation. Okay, so the basic concept, as we just talked about, generally a contract, a corporation is not bound to enter into that contract, on behalf of itself, or on its behalf prior to its existence. But it can, if there is a ratification, an adoption and a ratification, right? And ratification is defined as that affirmance, that agreement by the person of the prior act, which did not bind him, but which was done on his account. So now a corporation may, after its organization, become liable on those preliminary contracts made by the promoters by expressly adopting it or by receiving some benefits from them. So even though the corporation, the Inc., was formed after the execution of the agreement with the LLC, which was never properly formed, Gyrographic did work to developing letterheads, cards, and other marketing materials for the Inc. The Inc. made payments to Gyrographic, which Smith Stearns Yacht Inc. then recorded in its books, and Smith Stearns Inc. received the benefits. So even though there was no sort of formal ratification, the point of this case is even though there was no formal ratification, again, the parties' conduct, at least by this court, was looked to be quite relevant because Gyrographic did work for the Inc., not the LLC. Even though the original agreement was with the LLC, the parties started to act in a way where Inc. was receiving benefits and Gyrographic was providing benefits. Inc. made payments to Gyrographic. Gyrographic took those payments. Smith recorded it in its books. They received benefits. And so the point of this is this ratification, this adoption, this acceptance doesn't need to be expressly written down. It's better if it is. Here it was not. But based on the parties' conduct, the court said that was good enough. What's most interesting about this case is that there was no novation, no formal novation of the agreement, no formal assignment of the agreement. But again, the court is implicitly saying the parties' conduct, specifically not Smith Stearns now, but Gyroscope, the company that's providing the marketing services, was providing marketing services to the Inc., not to the LLC, and therefore, and got paid for those services, by the way, that would be deemed to be an acceptance or an acceptance of that assignment or ratification of the contract from the LLC to the Inc. So there you have it. You know, adoption, ratification, novation, those are the basic principles for pre-incorporation contracts. This particular case is saying those are still the requirements, but you may have circumstances where, based on, again, on the parties' conduct, despite what they may or may not have or failed to write down, based on the parties' conduct, that could be enough as well for the court to say, check the box. Yes, there was adoption. Yes, there was ratification. Yes, there was even, assignment. Here there was deemed to be assignment, novation, nothing express, but there was in the sense that Gyrographic was giving benefits to the new company, the company they didn't originally sign the agreement, and they received benefits in the form of payment. That was good enough. Okay, pre-incorporation share subscriptions. We don't need to worry about that. You should know that a promoter does owe a fiduciary duty to the corporation and to its prospective investors. Just because the corporation hasn't been set up yet, they will owe that. There's nothing, interestingly, that requires a promoter to be compensated in any specific or particular way for their expenses. It's really going to be up to the corporation to to adopt and ratify whatever reimbursements or other fees should have been paid to the promoter. At the end of the day, it's really what agreement you can set out. And again, I consistently urge for us to always have an agreement, not just any agreement, but to get a good agreement in place. Okay, so how do we go about incorporating? We've talked a bit about incorporation now. How do you go about incorporating? Again, anybody can incorporate. It's going to be a state law thing, but what do you need to do? You need articles of incorporation. Those are that's the basic document that you file with the Secretary of State in the state that you want to be a domestic corporation and not a foreign corporation. You file those articles. What do you need? Figure 1 tells us it's basic stuff. The name of the corporation, the number of shares that the corporation has authority to issue, the address of the initial registered office of the corporation, the name of the registered agent, the name and the address of each incorporator, just sort of the basic sort of things. The following may also be included in the company's articles of incorporation: the address of the individuals who are to serve as the initial directors, the purpose of the corporation, the duration of the corporation, the par value of the shares, and additional provisions not inconsistent with law for managing the corporation, regulating the internal affairs of the corporation, establishing powers of the corporation and its directors and shareholders. But the basic is, the name of the company, number of shares that they have the authority to issue, and the address of the initial registered office of the corporation and the agent. Why you need a physical place where you can communicate with the corporation, because again, it's this fiction that's created. Who's standing behind it? You need the address and name of each incorporator, and obviously you need a name of the corporation, and as I said, the number of shares that you have the authority to issue. Say you want to say, 1 million shares. Well, if you then realize after issuing all of your authorized 1 million shares after the corporation has been established, you need another 1 million because you're bringing on new investors or you have more employees you want to give shares to. Guess what? You got to go back and amend your articles so that you increase the number. So it's a good idea to start with a larger number so you don't have to keep going back and continuing to amend. There's no harm in simply having a lot of authorized shares and not necessarily issuing all of them just yet. Okay, contents of the bylaws. What's the distinction between articles of incorporation and bylaws? Articles of incorporation deal with kind of the basic sort of stuff. The articles of incorporation deal with the most basic sort of stuff. They talk about the very particulars of the name, who's the agent for service of process, and how many shares you have to be issued. By contrast, the bylaws really deal with kind of the governance or operation of the company. They're kind of the constitution of the corporation. So both bylaws and articles are very important in their own way. Bylaws are important, articles in the sense they're critical and important in establishing the company, giving it life. But the bylaws really set out in greater detail how the corporation should be run, how many officers, how many directors, when you hold your meetings, what percentage of the shareholders are required for certain events or activities. If you say sell the company, or what happens to shares, how you can bring on new shareholders, what committees on the boards of directors might be needed, the requirements for setting up special meetings. All those sorts of things should be enumerated in the bylaws. So Figure 2 gives us some examples, also repeating some of the ones I just said, but highlighting a few others. The authority of the officers and directors, specifically what they may or may not do. And again, officers and directors all have fiduciary duties. You can't get around that even in the bylaws. You can't say, our officers and directors are going to be different. They'll have no fiduciary obligations to the company. You can't circumvent or get around the statute in that way. But you can say, the authority they may have relative to, what they can purchase or what committees the directors are expected to participate in or what sort of officers you intend to have, etc. The time and place in which the annual shareholder meetings will be held. The procedure for calling special meetings of shareholders. The procedures for shareholders and directors meetings, including whether more than a majority is required for approval of specified actions. The provisions for special committees on the board, defining their membership and the scope of their activities. The procedures for the maintenance of share records. The machinery for the transfer of shares. And the procedures and standards for the declaration or payment of dividends. That's actually a very important one, obviously. Shareholders are going to want to know, when their dividends can, under what circumstances. And similarly, directors and officers are going to probably want to give some guidance in that regard too. Let's talk a bit about defective attempts to incorporate. Again, we talked about the need to follow corporate formalities. That's a very critical form, and your failure to follow corporate formalities can have severe consequences, including, but not limited to, up to the piercing of the corporate veil. So you want to really get out of that and avoid that if you can. There is this notion of a de jure corporation, and a de facto corporation. What's a de jure corporation? A de jure corporation is when the promoters comply with all the relevant requirements of the statute. And it's treated as a corporation. You've basically followed everything that you need to do. Okay, so you filed the articles of incorporation properly. You know, you've basically done what you need to do. That's de jure. De jure is a Latin meaning of law. So you're legal. You're thumbs up. You're good. De facto corporation, again from the Latin de facto or in fact, means in fact the corporation does exist still, even though the incorporators fail in some material respect to comply with all the mandatory provisions of the incorporation statute. So you've done all the basic things you need to do, except you failed to maybe, do some relatively minor thing. You've made a mistake. In that instance, the courts will say, you know what, you're 90% there or 95% there. It's good enough for now. You'll be treated as if there's a corporation. The upshot of all this is if there's no de jure corporation, meaning you basically did everything you needed to do, or there's no de facto corporation, meaning you did most of everything you needed to do, but not all of it, but still good enough. If you're neither of those two, where are you? You don't have a corporation. So all the acts that you've committed on behalf of the corporation, or what you thought were acts on behalf of the corporation, were in fact not. You're going to be on the hook as a promoter or another person, as an individual, as whatever capacity you may have been acting. But whatever it is, there is no limit of liability benefit. Because why? There's no corporation. The law will treat it as if no corporation's ever been established. So you've got to be very careful to properly follow the rules. De jure or de facto is okay. But if you're neither of those two, you don't have a corporation. The effect, you're personally liable for breach of contracts, for tort claims, etc. So you have to be very, very careful. That's the de jure versus de facto distinction. The incorporation for nonprofits, as I said, we're not going to worry about. Let's talk a little bit about financing of a corporation, because this is a very important concept, of course. In the financing of a corporation, there's really kind of two main formulas that you can do, right? And again, it's sort of common sense, right? You can either go with debt or equity. And what do we mean by debt? What's included in debt? Simple English, it's what? It's getting a loan, right? Going to a bank, going to some other lender who will extend you money. And there's plenty of organizations out there that will be prepared to do that, or at least consider doing that to small businesses. And there are government-backed loans through the Small Business Administration and other vehicles. But the bottom line is, debt is a common way to finance a business and a company. Another form of debt is not just bank loans, but through the bond market and bonds. Larger companies will issue bonds, essentially function as their own financer, but will sell an obligation to pay back the money that's loaned to them with interest to the bondholders. So, large corporations routinely have bond issuances, and it's a great way for them to raise money in the open markets through various people who are willing to extend money. It's not just lending institutions. Now, smaller businesses, that's generally not going to be a vehicle that's available to them. But the point is, a bond really functions, if you think of it, no different than a bank debt, in the sense that it's someone giving you money, but you then are promising to pay that money back with some sort of interest, with some sort of additional fee over time. So that's one way to finance. The other way to finance is the good old-fashioned way, which is equity. And what do we mean by equity? Essentially giving somebody an opportunity to own a piece of your business. So you say, hey, you want to own 10% of my business? Pay me $100,000. You can now own a portion of my company. That gives you an opportunity to do that. That gives you equity in the company. It's another way to raise money. I mean, we talk about frequently companies in the context of public companies raising money through initial public offerings. That's what would be a form of equity. You're selling your shares to the general public, but it doesn't necessarily have to be that. There's a lot of private equity that's out there. There's a lot of so-called angel investors, friends and family who are going to invest, or be prepared to invest in a business. In return, they're getting a percentage ownership. Now, what are the respective pros and cons? I mean, here you could say, well, I don't have an obligation to owe anybody money, or my corporation or my business doesn't, but I now no longer own all of it. I'm now a shareholder with someone else. In the context of the debt, I don't have that problem. I still may own it all myself, but I have this obligation to repay back some other party. So it's a constant, shift between which may be a preferred method. Each circumstance will, of course, differ and depend on your situation. Now, let's talk a little bit about the types of equity that can be offered, because there are different types. If you've got a C corporation, for example, you can offer what we call common. And the other thing I should mention is, in the context of S corporations, you cannot have different classes of shares, which is another reason why people like the C corp. But we have, distinctions between, in a C corp, common versus preferred stock. As its name suggests, common is just, ordinary, regular stock. Not bad, great to have. But preferred, as its name suggests, gives you and confers some sort of special right, or not obligation, some sort of special right. So what might those rights be? What sort of rights might a preferred stockholder have? It'll depend on the circumstances, but certain examples might be, there could be preferred voting rights. Okay? Suppose, for example, that you're a shareholder, you're bringing in all these other shareholders, you're concerned about losing control, but you really need this extra capital. You don't want to get the debt. So you say, okay, fine. You can be a shareholder. You can maybe own 30% of the company in terms of the outstanding shares, but my shares are preferred, and for every one vote that your share, mine counts as 7, let's say. That sort of stuff occurs. So being a preferred shareholder could mean preferred voting rights, extra power. Your shares are extra powerful in their voting rights. That could be very good thing to have, right? A very valuable thing to have. What other preferred rights might you have? You may have a dividend preference, so that anytime a dividend is distributed, you then have the right to receive the dividend before the common shareholders, right? Again, a very powerful thing to have if you can get it. Being a preferred shareholder with a preference right for dividends, also huge. What's another one? A liquidation preference. If there is a liquidation of assets or stock or the company, well, guess what? Based on whatever your agreement calls you being paid for, you're not treated the same as everybody else. You're first in line to get paid before everybody else, and whatever else is left over, fine, the other guys can get, but I get first rights to be first in line to be paid if there's a liquidation event of the company. Again, another very powerful right to have if you're if you're a preferred shareholder. The other thing you may get is what's known as an anti-dilution right, which means, you know, if we talked about when you file those original articles of incorporation, and this is a really important point, you file those original articles of incorporation and say you've got a million shares, right? Well, after that 1 million shares is already not just authorized, but now issued to the other shareholders, you want to issue new shares because you want to bring in more investors. Well, say you bring in another million. Say you're among the first 1 million shareholders and you own 20% of the company. Well, suppose another 1 million shares are issued after you've already owned 20% or 200,000 shares. Suppose you're issued no new shares, however, in the second issuance. You still have your 200,000 shares, or 20% of 1 million. That's true. But as a proportion of the total actual shares that are now issued, your 20% has now become what? It's no longer 20% of 1 million, it's 20% of 2 million. So you've gone from 20% to what? To 10%. We then say your share interest has been diluted or reduced, right? That's a very, very unpleasant and unfortunate outcome if that happens, but it happens all the time. So you may want protections against that eventuality. We call that anti-dilution, and you can get that potentially as a preferred shareholder. So if you could be preferred, that's, no pun intended, highly preferred. Okay, so common versus preferred. Don't worry about the rest of the stuff. Well, actually, let me mention one more. There is also, you know, what we call maybe a convertible preference, where you may have some right to convert your shares to debt, right? You sometimes have those rights, and that convertibility sometimes often goes the other way, where you've got debt and convertible to equity. So that's other things we can do with potentially to play with it. But otherwise, that adequately covers the preferred discussion. And again, for our purposes, and I've mentioned this a few times already, if it's not discussed in any of these lectures or in class, then it's not going to be on the test. I'm not going to test on things that we don't actually discuss or cover. So that deals with common versus preferred and some of the extreme advantages of preferred. Dealing with authorized or issued, again, the authorized is just what's written in your articles of incorporation, right? I have up to 1 million authorized. The number of issued is how many shares of those authorized you've actually issued to your various shareholders. This number of issued shares can never be greater than this number, right? If it is, then that's a real problem. You can only issue up to your authorized number of shares, right? So it's how many shares you have authorized, and this is going to be stated where? In your articles AIC, Articles of Incorporation. It'll be stated there, your number of authorized shares. And then you can determine, okay, of those number that are authorized, how many can I actually issue? Let's talk a little bit about options. Options are a type of equity, and it's merely the right to buy a stock at a particular price by a particular date. So options are often offered to employees of a company to incentivize them. Again, this pay-for-performance concept. If I get the stock price higher, the company benefits, the shareholders benefit, I also benefit as the holder of that stock or the holder of those options. So to give a concrete example, suppose I have an option in a company, Company X. I'm an employee of Company X. I'm given 100 options. And the price we'll call the strike price, meaning the date the option is granted is I'm granted those options at that day at that particular price. So say 100 shares, and say the stock is trading, it's September 1st, 2015. I'm granted 100 shares and it's trading at $10 a share. Okay? Now what does that mean? I have no right to buy those shares yet. I just have the right at some point in the future to buy those shares. Furthermore, I not only have the right to buy those shares at some point in the future, I have the right to buy those shares in the future at this price of $10. Okay? So what's the value of that? The value of that is that we hope that the value of those shares is going to do what in the future when I actually will hopefully buy those 100 shares? Not going to go down, going to go up. So if it goes down, these options have no value to me. The only expectation is that the value will be if they go up. So suppose the share price in 3 years goes up to $15. And we also, so it's September 2018. What happens now? I have the right to buy the shares at $10. So what does that mean? They're trading at $15 though. So I pocket the difference between $5 and $15 and $10. That's the value of these options, is I get to buy the difference in that price. So I always have to hope, if I'm a shareholder, I'm an option holder, that those prices in the future go up, and I get that difference. If the price goes down in 3 years, if it's not trading at 15 but at $5, I would never exercise my option. What would I do? I would sit on it. Because if I actually exercise my option, what would I have to do? I'd have to come up with $5 per share to buy it at 10. Why would anyone in their right mind do that? I would be losing money. I'd actually be paying the equivalent of $500, the difference between $10 and $5 times 100 shares to get those shares. I could just go to the open market and pay $500 and get 100 shares as opposed to paying $1,000 for shares that are worth only $500. Typically, options are going to also be bound by time, meaning they vest or become valuable or exercisable over a period of time. So those 100 shares are going to be granted to me on September 1, 2015. I can't actually exercise them or use them until they fully vest. So say they vest in 3 years. From that point forward, I can exercise my rights or purchase those options. And usually I have a period of time well beyond that to do it, but usually not forever. Usually the right ends after a long period, after say 5 years or 10 years or something like that. So the hope is I can continue to watch how the share price is doing and eventually to go up beyond my strike price so that whatever price that goes up to, I can then purchase it and pocket that difference between the strike price and what it's trading at that particular day. Again, you see how there's this attempt to align business interest, pay for performance, the interests of the performance of the corporation with my payment, and that hopefully I'm contributing to that increase in stock price, and I'll be incentivized to drive value so that stock price will continue to go up and go higher and higher. As I said, these are good incentives to employees, and are widely offered as such. Par value, you sometimes see that terminology. That's on 1063. That's just really a kind of an arbitrary number that's assigned to shares for the articles of incorporation. It doesn't really reflect any particular inherent or intrinsic value of the company or the value of the shares. The rest of the discussion, I think, is is probably good if we stop there. I'd like to, in the next class, talk a bit more about capital structure and options. I'll have a few more words to say about that, but we'll really pick up on management of corporations, chapter 30 or 43, to a lesser degree 44, shareholder rights and liabilities. But once we get through that, we'll be done also with corporations. So thank you again for your time, and we'll be in touch soon.